I wanted to welcome everyone. My name is Richard Rom. I'm president of the California Supreme Court Historical Society, and I wanted to welcome you here today to honor the recipients of the Selma Moydell Smith Student Writing Competition in California legal history. I wanted to say that the competition was first proposed by Selma in 2007, and she's been running it ever since. In 2014, on the occasion of her 95th birthday, the competition was named after her. The competition this year was judged by distinguished legal historians, Professor Stuart Banner, UCLA School of Law, Professor Emeritus Christian Fritz, from the University of New Mexico School of Law, as well as Professor Sarah Mayu, the Vanderbilt University School of Law, who incidentally was the first place winner of the competition in 2010. Before we go on, I wanted to say that if you hear large banging sounds or things like that, I am on vacation. I'm on the coast of Washington without phone service, but have Wi-Fi service. So please bear with me if I'm distracted. Next, I would like to introduce the Chief Justice of the California Supreme Court, Tani Cantil-Sakauye, who's been Chief Justice for 11 years now. The Chief Justice has championed the cause of bail reform, and she leads an initiative called The Power of Democracy to support civil discourse education for students. This is my own opinion, but I think that during her tenure, there have been an incredible number of, maybe a record number of unanimous decisions on the court. Again, I haven't done an analysis, but it seems like a record to me. And congratulations on that. Finally, and perhaps most importantly, the Chief Justice is also chair of the California Supreme Court Historical Society. Next, I would like to introduce a former Associate Justice of the California Supreme Court, Catherine Mikla-Werdiger, who is also a longstanding member of the Society. Justice Werdiger, who a couple of years ago retired after 23 years on the court, was then and remains a champion in environmental law. She has also funded and established a student travel grant to help California legal history research. And finally, there is Selma, our Selma. Selma became an attorney in 1943 and practiced for 40 years. She took over the editor-in-chief position of the Society's California Legal History Journal in 2009, doubling its size and making it into the preeminent journal it has become. At 102, Selma has remained a leader in the legal profession, being honored by the ABA, the Lawyers Association, and almost every other known legal organization, and then some. And did I also mention that Selma was honored by the UCLA School of Music this year by the creation of the Selma Moydell Smith Annual Recital, recognizing Selma's 100 plus musical compositions. Without further ado, Chief, I think this is where you give your greeting.
Thank you, Richard, and thank you for being such a excellent and I want to say inspiring a chair of the Historical Society, and how you led in time of crisis, and that the work of the Historical Society has only flourished under you. I also want to say hello to Chris, for whom so many things with the Historical Society, including us being here today, could not happen. And I'm going to save the best for last, and that's Selma, but I will say also, when Kay and I served together on the California Supreme Court, it was a joy, always a learning experience. Kay Werdiger is a force, an intellectual force, and poised and graceful. No one can exceed that. And every day we miss Kay. And many of Kay's dissents turn out to be, later on, resounding majority opinions. And so, Kay, if you don't already know it, we miss you dearly every day. Your name has not faded at the Supreme Court and amidst our discussions. And so it's a pleasure to see you. Now, let me just save this, Selma. As you know, this writing competition is named after Selma. because it's Selma's brainchild. But Selma is the mother of countless, infinite number of tremendous ideas in the legal field. I hope you have a chance, if you have not already, Googled Selma. Selma has created, started, inspired, been a part of, and this is important to us here since all three winners are female, the female empowered movement in the law. Selma Moydell Smith is the conqueror, the starter of that at a time when it wasn't necessarily popular or understood or considered anything that anyone would join. But Selma has been a tremendous, remarkable, extraordinary voice. And she inspires, she mentors, she sponsors, and I'm proud to be in her company. So when you hear Selma speak and address you, you'll know what I'm talking about. We've also had the pleasure, Kay and I, as well as another justice from the California Supreme Court, Carol Corrigan, to honor Selma many times. And one of our most recent opportunities, they played some of Selma's music, the music she composes and plays, and we had the pleasure of sharing the stage with Selma as she led us through some of her music. I'll be brief in terms of the rest of my remarks, only to say how impressed I know I am, and all of us here are, not only with the topics that you chose to write about, which reflects your awareness and your keen insight into the issues that trouble our legal profession and hence California and the United States today, but that I look forward to reading your inner thoughts regarding these ideas. But what you have touched upon in terms of, well, Kaylee, with vagrancy and racial exclusion, sit lie, and the right to exist in public, how poignant that is, especially now, more than ever. So the fact that you were able to anticipate and write this in a time that now means so much to us will serve you well in your years to come in law school because you're prescient. And then, of course, to Brooke, for getting to Tarasoff, a gender-based history of tort law doctrine. Tarasoff continues to be a case of such magnitude that we discuss it regularly at the California Supreme Court. And I look with interest your view on this with, as you state in your title, the gender-based history of tort law. And of course, next, let me say, Kelly, your article on California wrongful incarceration compensation law. I don't know that there is a week that goes by that we don't read about something like that in the paper. And when we talk about something like that, of course, it brings with it the weight of what has happened to a person because of wrongful incarceration and the contrariness that is to our justice system. So your insight is also important for us and reminds us about the important work we should be doing always fairly and accurately and with transparency. So I look forward to your articles. I congratulate all of you and wish you the best. I turn this over next back to you, Richard.
Thank you, Chief. So now that we've heard something about these papers, I'd like to hear them described. So the first place winner went to Kaylee Berger, who will be in the class of 2022 at UC Irvine School of Law. Kaylee's paper, as the Chief mentioned, Surveying the Golden State, 1850 to 2020, Vagrancy, Racial Exclusion, Sit Lie, and the Right to Exist in Public. Kaylee, can you tell us something about yourself and something about your paper?
Hi, yeah, so I'm a JD MBA candidate. I'm going into my fourth and final year at the amazing UC Irvine School of Law, and I have recently accepted an offer to join Kirkland & Ellis after graduation as a corporate associate, and then after that I will actually be clerking on the Ninth Circuit. So I have an exciting future lined up. And my article traces legal and quasi-legal policies that criminalize the right to exist in public. These include early vagrancy laws aimed at Indians, greasers, Okies, Chinese racial exclusion, sundown towns, sit-lie ordinances, and probably a more recent phenomenon of these civil unrest emergency curfews. And my point in highlighting the ways in which the Golden State has participated in or even innovated discriminatory law and policy is for the reader to consider the potential similarities between these contemporary laws, such as sit-lie and temporary curfew laws, and older laws that we actually now consider embarrassing. Are they aimed at removing a population that is broadly disliked? Are they legitimate concerns or a pretext? Does the enforcement broadly infringe on recognized liberties? And these are the questions that I want my paper to invoke. When not only when you look at these old laws, which we now all can agree are not our state's proudest moments, but recent laws and laws that still exist today.
Kaylee, how did you come about, or was there some specific event that occasioned this paper?
Yeah, so actually, I wrote this paper last spring when a lot of the George Floyd protests were going on, and these curfews were being put in place in California. And whenever I think of curfews and civil unrest, I often think back to the Rodney King incident and those protests, and the amount of people that were arrested and actually hurt, and people who died during those protests. And some of that was at the hands of law enforcement. Enforcing those curfews. And so I wanted to make a statement about, at the time about how I felt about that incident that was going on at that time, and relate it back to, California's history, because we think of California as, a lot of people think of it as a very liberal state, and it is, and there's a lot of liberal policies, but maybe that's because, we're considered a sanctuary state. California gave COVID aid to undocumented immigrants when the federal government didn't. California has done some amazing things, but we also have been an innovator in discriminatory policy as well. And so I did want to highlight that.
Thank you very much, Kaylee. Our second place winner was Brooke Talca, who graduated this year from Boston University School of Law. Brooke's paper is entitled Getting to Tarasoff, A Gender-Based History of Tort Law Doctrine. And Brooke, can you tell us something about yourself and how you came to write this?
Yes, definitely. So I graduated this past spring from Boston University. I was a dual degree JD and MA in history student. So definitely always been interested in history and knew I wanted to write some legal history papers during my time in law school. I've now moved back to Wisconsin, which is where I'm from originally. I'm working at a small plaintiff side employment firm here. And I really came to this idea just in my 1L torts class when we first read Tarasoff. I was just really struck by all the different things that I felt were going on in this case as far as issues of like national origin, race, gender, domestic partner violence, and all these things, and how those dimensions aren't necessarily usually talked about in like a 1L torts class. We focus kind of on the issue of duty and that kind of role rather than the more in-depth issues. So I really wanted to kind of look backwards from Tarasoff and kind of see, was this decision really in line with prior decisions? Did it represent kind of a turning point? And so I looked backwards to different torts that disproportionately affected women. And these had a very wide range from early breach of promise cases, which involved women bringing suit for a man's failure to follow through on a marriage proposal, all the way to bystander claims for negligent infliction of emotional distress, which usually disproportionately impacted women in caretaker roles, usually with a negligent injury to a child or spouse. And also even up to the present day with contemporary issues of revenge porn on the internet. There's just kind of a lot of gender dynamics of torts that I was interested in. So taking a historical look more closely at California, I argue that Tarasoff represents the culmination of an expansion of tort law in California to include recovery for situations that disproportionately affect women. And I also discussed a little bit about how this didn't necessarily take place in a vacuum, but there also was was, of course, a large women's rights movement going on at this time. And there was a lot of activism geared towards bringing greater attention to domestic abuse and violence against women more broadly. So I kind of examined that as well to look at how this was able to bring more attention to the issue of intimate partner violence, which was at issue in Tarasov.
And as you mentioned, you also go past Tarasov to the present. And I think one of your observations was that there's been some kind of retraction in the Tarasov doctrine. You want to say something about that, or?
Yeah, so looking a little bit past Tarasov, I kind of argue that Tarasov represented the culmination, and then following that, there was a bit of a retraction, which seemed to be tied kind of to a rightward shift on the California Supreme Court. So that kind of helped as well to show how Tarasov fit within the broader framework of torts in California.
It's great. I very much appreciated looking. When we're in law school, of course, we learn about duty of care and breaching that duty and what have you, and to look at this from a different perspective, that is from the lens of women's rights, I thought was extremely interesting. Go now to the third place winner, Kelly Shea Delvac, who also graduated this year as well. She from Pepperdine University School of Law. And Kelly's paper is entitled California Wrongful Incarceration Compensation Law, a history that is still being written. Kelly, could you tell us a little bit about yourself and about your paper?
Yes, thank you so much. Can you hear me?
Yes, very well.
Okay, sorry, I'm on my phone because I too am on vacation. So working with what we have. Ms. Selma, first, thank you so much for running an amazing competition, and it's such an honor to be on this call with all of you. So thank you. I come to the law a little after a career as a circus performer. So but the law is just as thrilling as being a circus performer. So I just graduated from Pepperdine Law. I just took the bar exam from my home, and that was a harrowing experience. But writing this article was amazing. I had done another article arguing for wrongful conviction as a Fifth Amendment taking, and to give some compensation that way, because there are many states that don't have compensation statutes for people who have been wrongly convicted. So I wanted to see what has California done, and I was so pleasantly surprised by just the history. You know, the first wrongful conviction was in 1852, and really wrongful convictions have gone since the beginning of our statehood. And in 1852, when it happened, people actually raised a fund for this man who was wrongly convicted, and the court refused to give it to him because they said, in society, too often are wrongly accused of crime, and the government has no power to release them. And so that that's horrifying at looking back on that, that's their misfortune. But California has responded. In 1913 was the first time they passed a compensation statute, and really every kind of decade, and more so even in recent history, every few years, they've kind of tweaked the statute to make sure that those who are being wrongly convicted and who have been wrongly incarcerated are not missing out because maybe there was a bad fact on their side, or the compensation board, they used to have a totally separate ruling on the merits, separate from the court, and that's kind of been abolished. And so there are still tweaks that can happen, and California has been responsive, and it's just such a testimony to the heart of our justice system here in California that the judiciary does seek justice and seek to right the wrongs that do happen, because we know they happen, and it's what we do after the fact. And so that's why I titled it, It's a History Still Being Written, because unfortunately it'll probably never happen that we won't have any wrongful convictions, but at least when we have them, we can reverse them, and then we can also compensate as best as possible.
I thought it was particularly interesting, Kelly, the agency that approves the compensation for those who have been wrongfully convicted one of the things is, as Kelly points out, you have to show that you were damaged in terms of your worth, your compensation, things like that. Of course, someone in prison isn't getting any compensation. And it's not that simply you were thrown into prison wrongfully, and that would be a tort in and of itself, but rather to get reimbursement from the state, you actually have to show that you're not the sort of person who would be convicted and put into prison, which is also a type of demonization of anyone who's a little bit different, who might be put in prison because they look different race, nationality, things like that. I thought that was very interesting.
Thank you.
You know, what I'd like to do now, just for a couple of minutes, is just an overview of the papers, because they were all interesting in their own right. But, you know, starting with Kelly's, your paper, Kelly, was a history of a reform, going back to the 1850s to the present, that gradually it's working itself free, the law, and becoming better, and it is getting more reformed, and hopefully it will continue in the future. So it's a policy of reform. I want to look at it from social policy. Where do you see the law going in this regard?
I see the law being responsive to who we're leaving behind and changing to make sure that those people are not left behind. Recently, you know, we have a factual innocence ruling, and before 2016, the board that was deciding the compensation didn't have to take that factual innocence ruling. They could make their own. And in 2016, the court said, no, you have to take the exonerating court's ruling as the ruling here. And I think that, you know, that's just one example that as they continue to tweak and find, like, oh, we're leaving people behind, that they can continue. And I think the court has been very responsive to doing that, and I see that continuing.
Very good. Well, and then Brooke, your paper, by examining tort doctrine through a gender-based lens, points to different sorts of reforms that we might have. I thought a lot of the paper was focused on how one can see tort through gender-based lens. Where do you see that sort of policy, or leading to what sort of policy or reform?
Yeah, so I guess like some of the things I kind of mentioned in my paper about like more current issues involving torts against women, like with involving technology and the internet and things. I think that just kind of a greater awareness of the gendered aspects of some of these torts will lead to more legislative or judicial action in those realms, rather than having that realm be kind of ignored. So I think just kind of examining the more contemporary issues that are arising with more technology and everything through a gender-based lens will lead to some more acknowledgement of some reforms that need to be done in those areas.
Certainly enough that we're sensitized to what we're doing in the law when we either enact new laws or decide laws.
Yes.
I want to come back to you, Kaylee. Your paper was very interesting in that it was very much a cautionary tale of, here, things have gotten better, but remember that things haven't always been that way, and there's been a lot of demonization of the other, whether it be vagrants, indigents, African Americans, Chinese. At one time or another, these were all the other, and laws, public policy was against them. It doesn't end on a note of reform. And so I wanted to ask you, perhaps it's enough to say, be cautious in terms of using the state power. You have a huge hammer that you're wielding, be careful with it. But do you see it going towards some sort of policy or reform?
Yeah, I mean, so it's definitely a cautionary tale. And part of the tale is that it's not just law. Quasi-legal policies like sundown towns, it's just the way society was made it basically illegal to be in public if you were an African American person at that time. So I guess, the hope is that when we do pass laws and as a society, we think, for example, civil unrest curfew is a law that's beneficial for society overall. We consider that maybe it's not, and maybe that enforcement of something like a civil unrest curfew could actually lead to a lot of different discrimination, arrests, and even death. And so it's a paper to actually ask people to think, like, something might sound, obviously, what problem would you have with that, keeping the peace? What problem do you have with that? The problem might be the way it's enforced. The problem might be why the law was put in place, because what kind of people you are trying to enforce it against. And even if it's not the intent of the law, in practice, look at what the law does. And so it's asking people to think, and just remember that at the time each of these laws were passed, they weren't thought to be this horrible law. It wasn't thought, before they were more blatant, like it's if you're Chinese, if you're indigent, it was more obvious. But then law becomes not so clear, but who's enforcing against, if you actually look at the numbers and you actually do the research, it does become clear that the law is targeted.
You mentioned California's criminalization of indigency or bringing indigents into the state in the 1930s. Yep. And it leads perhaps to there may be reform and growth because with that case, they convicted someone of bringing in his sister and brother-in-law because they were indigent from Texas. And these were primarily against white people. White people in the 1930s, mostly Christian, Northern European, but they were indigent. And it was argued before the United States Supreme Court that California should have a right to keep these people out because they're syphilitic, they're inbred, low intelligence, they fill up the criminal calendars, and why shouldn't California be able to keep them out? The law got overturned by the US Supreme Court, but just to let you know, the Attorney General who argued on behalf of the state of California was Earl Warren. And so he later referred to this case, which was Edwards versus California, in support of his civil rights cases. So things can get better.
Yeah, and he's not, it's interesting. In my paper, I also talk about Governor Gavin Newsom, who at the time when he was mayor of San Francisco was actually a proponent of sit-lie, which is so interesting because you also see him as this very, kind of like Warren, like this very liberal policy for, the underdog. So it's very interesting when you look back and you see like who was making these decisions.
Absolutely. Well, what I'd like to do now then is go to you, Chief, for your responses, followed by Justice Werdiger, and then by Selma. Chief.
Thank you, Richard, and thank you for your probing questions. It makes us all think. And certainly in the business of law, that's what we do. And I, again, reiterate that I'm inspired by your thoughts, and I hope that all of you sometime in your future decide to either go into policy, go into judging, or advise someone who is in a decision-making position. Because of all the decisions that are made here in California that have been made in the past, that are going to be made in the future, are always influenced by current events and influenced by majority feelings. But it's imperative in the law and for sound policy that we all be critical thinkers. And as long as there is an us versus them mentality, we'll never win. And so I've appreciated all of your thoughts, and gives me things to think about in the future. Thank you. Thank you, Richard.
Thank you very much, Chief. Justice Werdiger?
I'm nervous connection, but I am so impressed with these 3 outstanding articles, all of which our law in California that we need to be educated about. The beauty of this competition that Selma established is it brings to mind for our historical society bits of history that perhaps would not be. The articles in particular give each of us so much to think about with respect to what's the good, the bad, and the ugly in California. The evolution of the law, we hope we're always going forward. We hope we're always correcting. So they are fascinating, and I am so and I congratulate all of you. So those are my comments. I look forward to returning to each of the articles. They are so educational. The bright futures that clearly are on the horizon for you.
Thank you very much, Justice Werdiger. And Selma, our Selma.
Did you hear it?
Yes.
Yes.
Congratulations to our 3 winning students, Kaylee, Brooke, and Kelly. And I want to mention that their papers that we are discussing will appear in our journal later this summer. I want to give a big thank you to my dear Chief Tani. Thank you for making yourself available again for this event. As the Chief Justice of California, you honor us with your presence and your welcome remarks. And I want to thank my dear friend Catherine, after your many years on the court, for the good thoughts and kindness you have brought every year since this competition began in 2007. And I want to thank our fine President, Richard, for his moderating, and our able Chris for making the arrangements. To everyone, thank you all so very much.
Thank you, Selma. You're truly an inspiration to all of us. Yes. And so to Kaylee, Brooke, and Kelly, thank you so much. Really enjoyed reading your papers, and also because I'm nerdy in this sort of way, please don't hesitate to reach out to me, email or otherwise to discuss your papers further. If you have other ideas, be more than happy to discuss those with you. Again, thank you very much, Chief, for your remarks. Thank you very much, Justice Werdiger. And thank you, Chris, for organizing and putting this all on. And thank you, Selma. I think this concludes this little awards ceremony. But this isn't goodbye forever, it's a beginning. So